Good morning, everyone. Welcome to our presentation today on how to manage a construction dispute. I'm Leslie Cho. I'm a practice leader in the disputes team here at LegalVision, and today I'm joined by Julia Simonovska. Before we get going, I'd like to acknowledge and pay respect to the past, present, and emerging traditional custodians and elders of this nation, in particular the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. If you miss out on anything today, don't worry, this session will be recorded and emailed to you. We've also got a chat box below where you can ask any questions you might have, and please don't forget to fill out the survey after the webinar. So in today's discussion, we'll be covering three main things. The first one is common pitfalls in construction disputes. Secondly, how to avoid those pitfalls. And thirdly, what to do when things go wrong. We'll then have an opportunity to ask any questions, and we'll end off by letting you know about our LV Pro membership program here at LV. So without further ado, let's begin. Common pitfalls in construction disputes. These are things that over the years we've found cause the most disputes and problems for players within the building and construction industry. Firstly, failing to understand the scope of services. As simple as it may sound, but more often than not, builders or contractors enter into a building contract of some sort, but fail to understand the totality of what they're required to do. This could include understanding the scope of the services you need to perform or the goods you need to supply, and what is excluded and included in the contract. This is probably more relevant for bigger contracts where there is a large project involved and a series of other duties is imposed on the builder or the contractor. For example, for some reason or another, we've had a situation where a lead architect was required to take on a more project management role in a major construction project. As part of that role, the architect was required to coordinate all other consultants, including all sorts of engineers, landscapers, subbers, you name it, and it was required to sign off on the construction of the works in accordance with the approved plans. In those circumstances, the architect would need to know the scope and limits of their role. For example, an architect cannot sign off on structural or stormwater drawings, but they may be required to coordinate other stakeholders to prepare those drawings. To the extent certain matters fall out of your expertise or knowledge, ensure there are certain carve-outs and limitations of qualifications with respect to any matter you are required to sign off on, including any statutory declarations you are required to execute. For example, lead contractors are usually required to sign declarations to the effect that certain works were built in accordance with the approved plans. Now, as an architect, you normally wouldn't sign off on whether structural parts of a build complied with certain engineering drawings. In those circumstances, you would make it explicit that you had relied on someone else's expertise when signing off.
Another common pitfall that arises in construction disputes is failing to understand obligations, procedural and formal requirements. These obligations can be prescribed by the contract as well as relevant legislation and regulations. This can include administrative type tasks that a party is required to perform under a contract, such as general obligations to retain a certain type of insurance or level of insurance, or certain types of certifications. Procedural requirements could also include things like, for example, the main elements of managing payment claims, such as the timeframes for submitting them, what information they should include. It's important to know and regularly update yourself on what these requirements are. For example, if you fail to issue a payment claim on time, or if it doesn't include key elements prescribed by the contract, some contracts include a provision whereby practical completion is deemed not to be effective. Another example of these types of procedures or obligations is the procedures for preparing and submitting variations, or where the construction work is split into a program, so it's based on separate stages of work. In those circumstances, it's important to understand what's involved in each of those stages, the timeframes for completing them, and when you can issue invoices. These programs will also include timeframes for reaching practical completion of the entire project. Builders should also keep themselves abreast of the formal obligations and requirements prescribed under relevant legislation and regulations, such as Home Building Acts and security of payment legislation. For example, this could include the requirements to hold a building licence, the maximum amount of deposit that you can charge under a contract, and the warranties for consumers and contractors.
The next common pitfall is not documenting everything in writing and obtaining acknowledgements from the other side. Oral agreements and handshake deals, while practical and widespread in the building and construction industry, it won't help you when things start to go sour. Commit everything to writing. For example, after your handshake deal in the morning, go home and send an email to the other side when you get just to confirm what was agreed. For example, including there any specific terms, prices, or dates. That email will provide a contemporaneous record of your agreement, which solicitors love. Perhaps you might also keep a site diary or a work diary, which includes any important discussions you had that day or the works you actually performed. Again, while that diary won't be perfect, it still provides a contemporaneous record of what you did and what happened at any particular day. This is the type of evidence that lawyers typically look for, and it's also good for information management on your end. Another pitfall is not dealing with issues relating to delays, extensions of times, and completion dates in a proper and timely manner. This is one of the top causes of disputes in construction and is particularly important when liquidated damages are in play under the contract. Delays can arise at any stage of the dispute, including at handover, and should be identified and dealt with as and when they arise. You would need to identify quite early on how any delay will affect the progress of the construction. For example, if handover is delayed by 2 weeks, this would then necessarily require an adjustment to the existing construction program by the same amount. As before, everything should be in writing, and ideally, any agreement should be reached and documented, and any extensions of time sought before proceeding with any further works.
Another common pitfall that arises in construction disputes is defects. These can occur at any stage of the contract, but particularly during defects liability periods and after completion. Each of the parties should identify and understand their rights and liabilities with respect to those defects, including who's responsible for them, what they're required to do if a defect does arise, and by when they're required to do it. There are some contracts out there that limit a builder's liability for defects equivalent to a small proportion of the contract price. This is something that you should be aware of from the start of the contract and before the works commence. Like always, it's best to deal with defects as and when they arise and in a proactive manner. This is especially so if you're relying on security being released at the end of the contract. Failing to do so could lead to protracted disputes between the parties, which can lead then to parties spending a significant amount of time and money to deal with defects, and it can also completely sour your professional relationship. If there is any sort of a dispute as to whether something is a defect or not, it's best to have those investigations done promptly and as soon as the defect is identified.
Variations. I attended a seminar earlier this year conducted by a number of liquidators. During that seminar, one of my key takeaways was that variations were one of the main causes why construction companies fail. This is because builders or contractors, more often than not, fail to deal with variations adequately or in a timely manner, which then often always causes cash flow problems. As mentioned earlier, it would be best practice if everything was in writing and if you maintain a proper data management system. However, with variations, it can be as simple as having a quote for variations being signed off by the principal or the head contractor and keeping it in your records. It's also important to know how to administer variations under the contract. The obligations are usually quite strict with respect to compliance. It can determine whether or not a builder is entitled to claim a variation, particularly for the purposes of a payment claim. All of this might seem administratively burdensome, but for bigger jobs, it can save you a whole lot of headache and reduce the risk of your company and business from failing. Lastly, having variations properly documented would also greatly assist solicitors if you need to engage them down the track, for example, for SOPA types disputes. Finally, progress claims. Progress claims typically need to be detailed and must comply with technical requirements under the contract and under the relevant SOPA legislation. For example, with progress claims, you tend to only issue you tend to issue them once a month. You also need to have specific reference dates. You must also have sufficient details of the work performed. And if you're in New South Wales, it needs to expressly say that it's made under the Security Payments Act. While a lot of these things are often complied with, those are the things that we as solicitors would typically look for if we were trying to knock out a progress claim. That is, we would try to do so on a technical point. For example, if it does not have the correct reference date or was served incorrectly.
So now we've understood what the common pitfalls in construction disputes are, but how do we deal with them and how do we avoid them? So one point is to maintain proper documentation. And this is a point that comes up time and time again in all disputes, but very much so in construction disputes of any size. We can't stress enough the importance of ensuring that you have a written record of all of your dealings, and that includes those with your customers, subcontractors, or even superintendents. These sort of written records could include confirming your in-person or telephone discussions via email shortly after they occur, especially if there's some agreement reached on a particular issue. Like Leslie said, you may also look into keeping a site diary or a work diary where you can regularly record important and contemporaneous information such as discussions, type of work performed, any instructions given to subcontractors, any issues or defects identified, or even records of inclement weather such as rain that may become relevant if you need to seek extensions of time in the future. You might also think about taking photographs to document the progress of the works or any issues that arise. These records can be kept at different sort of frequency. It may be daily, it may be monthly, but the key is that all of these records are ongoing. Another pointer is to follow any procedure prescribed by the contract. This could include specific procedures like how to deal with invoices. So the contract might prescribe the manner, content, and form in which you need to prepare invoices, as well as who it should be directed to. Another example is payment claims. So the contract could prescribe certain timeframes for issuing those claims and what they should include. For variations as well, the contract might include a detailed mechanism as to how to report and seek approval for variations, including the content and timing of issuing them and when you can expect to receive a response. It can also include any kind of notices, such as stop work notices or dispute notices. So things like what sort of information you should include in them, any timeframes to issuing them, and how they should be served. Another pointer is obtaining approvals and quotes. This flows on from the previous point about the significance of maintaining proper documentation. With important milestones and stages of work like approvals and quotes, it's vital to obtain them in writing and ensure that you receive an acknowledgement in writing from the other side before proceeding with the work. Because failing to do so could lead to disputes about what, if anything, was actually agreed or what in fact was quoted. Another pointer is properly understanding the rights and obligations under the contract. So it's helpful to continuously review the contract at every stage of the project and not to take any of its provisions for granted. So for example, just because you've utilised an AS4000 standard contract doesn't include that some later schedules that were agreed don't follow the terminology or may amend some of its terms. You should also regularly check that you are specifically complying with terms of the contract, especially if it's a longer building contract, as things might become missed during the course of the project that can become an issue at a later stage. By way of an example, we've assisted in a previous dispute as to whether or not a builder was entitled to certain bonuses under a construction contract, including bonuses for reaching practical completion early. What was interesting under this contract is that the calculation of the date of practical completion was based on business days, but the calculation of the bonus date was based on calendar days. So in fact, the dates arrived at were quite different. And in that case, the builder had not properly understood those intricacies of the calculations under the contract and had laboured on the assumption that it was entitled to a bonus when in fact it wasn't. Another point is to have clear programs and update the other side as often as necessary. In larger projects, builders may keep a master project program that they can regularly update and they can circulate to all of the relevant parties. Updates could also be as simple as informal correspondences like email updates. Sometimes superintendents keep an internal electronic register that records all communication, which different parties have access to. While this isn't practical for smaller jobs, there might be ways to replicate it in some way, like keeping a copy of all of your emails on a cloud server or organising them into separate folders in your email. With this said, if a dispute does come up and it can't be resolved, you need to understand what your rights are, including whether or not you can suspend the works. This may be a commercial option to take before getting into any bigger strife or having cash flow issues. All of the relevant terms of your agreement should be noted down in the contract. You shouldn't simply just rely on pre-contractual obligations that might not have found their way into the written document. And finally, maintaining a defect schedule. Again, following on the theme of maintaining the proper documentation, during the course of a construction project, it's very helpful to maintain a defect schedule and continually update it. They're usually prepared and maintained by superintendents for bigger projects. They're a useful tool to identify any piece of work that fails to meet required designs, workmanship, or material quality, and essentially help you nip any problems in the bud. The benefit of this is not only complying with your legal obligations, but also helping you implement quality assurance measures, managing your company's reputation, and possibly saving time and money on remedial work in the future.
Yeah, even if you follow all of those recommendations, things do go wrong. And what do you do then? Well, the first thing you would do is turn to the contract. In particular, look at any dispute resolution clauses you may need to comply with before taking any further steps. But it really depends on what the dispute is about. For example, if it's about variations, defects, or claims for extensions of times, then check the dispute resolution clauses. These are usually quite prescriptive and should be complied with. However, if you're looking at outstanding payments or payment claims, you would need to understand your objectives. If you want to get paid quicker, then think about if the SOPA is available to you. If it is, you wouldn't generally need to comply with dispute resolution clauses, as you would most likely run foul of the strict timeframes under the SOPA. For those of you who are not aware, SOPA, or the Security of Payment Act legislation, provides an interim framework to give builders cash flow relief, as it allows builders a quicker way to get paid with respect to disputed claims. However, it doesn't determine the final rights of the parties. Parties to a construction contract can always go to court for a final determination of their rights. In any event, it will always be open for the parties to engage in informal negotiations. In fact, this is highly recommended. Even if you're going under the SOPA, other than the time limitations allowed for in that forum, nothing stops you from engaging in informal negotiations. In fact, we've had parties come to a settlement before an adjudication application is lodged. However, if a dispute cannot be resolved informally, then you can think about taking a more formal approach. If your dispute relates to a payment of a progress claim, then you can investigate to see if the SOPA mechanisms are available to you. For example, if you've issued a payment claim and the other side has responded with a payment schedule that allows for an amount less than the amount you've claimed for, then you could consider making an adjudication application for a relatively quick determination of your claim. Or if you've issued a payment claim and the other side hasn't issued a payment schedule, in New South Wales at least, you can go straight to court for the amount of the claim, and the other side would generally be precluded from raising a defence. If you're on the receiving end of a payment claim, you would need to be careful when preparing a payment schedule. Payment schedules should be quite detailed and raise all of the reasons why you say certain amounts are not payable to the builder. This is because if the matter doesn't settle at that stage and it proceeds to adjudication, you generally won't be able to raise anything new in your response to that application. However, if the SOPA is not available to you, or if you do not like the outcome of the adjudication application, then the next course of action that would be available to you is to go through more formal means like commencing proceedings before the relevant tribunal or court. Prior to making such claims, you would typically need to issue a formal letter of demand setting out your claims and the relief you are seeking. In the event that you do not receive a favourable response, then that's when you approach the courts. Your claims at this stage will vary depending on your circumstances. For example, you might have a claim for a breach of the construction contract, negligence, breach of the Australian Consumer Law, breach of the Home Building Act or similar legislations, or perhaps equitable remedies might be available to you. However, going down the court process is usually a lengthy and very costly exercise, and often involves preparing a detailed evidence. It is therefore often the last resort. And on that ominous note, our formal presentation has come to an end. I think we can answer questions now.
So before we go on to the questions, apart from construction disputes, businesses can come into head with various types of disputes, and it might be helpful for you to download our guide to resolving business disputes by accessing the handout section in your webinar panel. We also want just to note that we have another webinar coming up for Startup Financing, Venture Debt 101, on Thursday the 23rd of June at 11 AM. You can register for this event at legalvision.com.au/events. Now we'll go on to answering a couple of questions that have come in. So
the first one's a great one. What specifically determines when a contract is on foot if it has not been signed? Firstly, just because a contract's not signed doesn't mean it's not already binding. It all depends on the circumstances. And it really depends on what kind of correspondence has been exchanged between the parties at the time and what conduct of the parties have been since exchanging that contract. For example, just because you don't sign a contract but you do everything else that's technically required of you under that contract, a court would easily imply that that contract was already in place between the parties.
That's right. So it's not the case that, a contract always has to be in writing. It might be the case, like Leslie said, that it's formed by certain discussions or conduct that happened at the time.
Next question is, if the works is separated by separable portions, is a critical part of each separable portions separated, or can all separable portions linked as a whole? That really depends on, well, firstly, that sounds like a really specific question, and that really depends on the terms of the rest of the contract. So we would need to review the relevant contracts, all its schedules, to understand where that could possibly take us.
Another question that we've received is, what is the relevant body to approach regarding bullying of a contractor? So it really depends on, what the bullying is and what the sort of conduct is. It might be the case that, the Fair Work may be open to you to approach, or even fair trading. But it may be the case that it is a matter that you kind of want to deal directly with the other side to try and sort out between yourselves.
In New South Wales particularly, I would go to New South Wales Fair Trading, as builders and contractors have certain obligations that they'd probably need to comply with.
Okay, well, I think, we've got another question.
What if you don't get approval in writing of your variations? So you still continue to carry them out? You run the risk of not being paid in full.
Yeah, so this kind of goes back to what we were discussing about making sure that you're following all of the procedures that are set out in the contract if you do have one. If there are certain procedures set out in requesting variations, make sure that you follow them. And if there aren't certain procedures, make sure to the best of your ability that you can obtain some sort of acknowledgement or approval in writing, and whether it be, by email or even just an email confirmation of some verbal discussions.
The main thing you would need to ensure is that the other side knows that work you're doing and why it is absolutely critical that you need to do it before any further works is continued, and see if you can get some sort of agreement from then on. Otherwise, that's when probably, if you don't want to proceed with the work, you would need to invoke the dispute resolution clauses in your contract.
Absolutely.
Okay, I don't think there's any other questions at this stage.
Okay, I think that's all of the questions. Thank you very much. So before we finish up today, we just wanted to take this opportunity to inform you about the unique membership product that's available at LegalVision, providing ongoing legal support to businesses. As part of our membership, clients can obtain unlimited document drafting and reviews, legal advice consultations, trademark applications, assistance with disputes, and quick turnarounds for legal work for an affordable monthly fee. You can find out more about this on LegalVision's website. Now, webinar attendees are eligible to receive a complimentary consultation to discuss how we can help you with your construction dispute. If you'd like to book a complimentary consultation, you can leave your contact details in the survey that will appear after this webinar ends. You could also email us at reply@legalvision.com.au and mention that you watched this webinar. Thank you all very much for joining, and we hope to hear from you all soon.
Thank you.